Hi, in this video we are going to analyze the Interest and Royalties Directive of the European Union through a case of the ECJ. The Interest and Royalties Directive is Directive 2003/49. This directive is based on the notion that inside or within the internal market, interest and royalties payment between associated companies of different member states, so cross-border situations, should not be subject to less favorable conditions than those applicable to the same payments made between associated companies of the same member state, so internal situations. The main principle of this Interest and Royalties Directive is an exemption from source state tax. In general, a withholding tax applied by the source state for interest and royalty payment made by the following agents. A company of a member state, provided that the beneficial owner of the interest or royalty payment is an associated company of another member state. So we need two different companies of two different member states. And the beneficial owner of the interest or royalty payment should be inside the European Union, but not can be in a third country. The case that we are going to study regarding this directive is case 150/16. In this preliminary ruling, the requests have been made in proceeding brought by three different companies established in Denmark relating to the obligation imposed on those companies to pay a withholding tax by reason of the payment made by them of interest to a non-resident company regarded by the tax authority as not being the beneficial owners of that interest. As we have said before in the previous slide, one of the requirements of this directive is that the company of the member state that receives the interest should be the beneficial owner. And we can identify the beneficial owner with the one that receives those payments for its own benefit and not as an intermediary for some other person. Article 5 of this directive of the Interest and Royalty Directive establish the following statement. Member states may, in the case of transactions for which the principal purpose of one of the principal purposes is tax avoidance, can refuse to apply the benefits of this directive. So in general terms, these Interest and Royalties Directives provides member state the possibility of not applying a withholding tax regarding the payment of an interest or a royalty, but this same directive permits member state not applying these tax benefits in the case in which this operation, the payment of an interest, for example, has as the main purpose tax avoidance and a scheme of tax avoidance or tax abuse. The facts in this particular case analyzed by the ECJ were the following. 5 private equity funds, none of which was a company resident in a member state or in a country with which Denmark has signed a double taxation convention under the OECD. Those 5 funds were established in 2005 a group consisting of a number of companies with the aim of purchasing T Denmark, a large Danish service provider. Those private equity funds and non-resident equity funds set up a company in Luxembourg called a Luxembourg holding, and also companies in Denmark, including N Denmark 1. The acquisition of T Denmark was financed by loans granted by the private equity funds to the company created in Denmark. So the scams were more or less the following. We have 5 private equity funds in a non-EU country, so in a third state. They have created a Luxembourg holding, established obviously in Luxembourg. And finally, they also have created 2 those companies in Denmark. The acquisition of the last one, T Denmark, was followed by the creation of different loans and with the payment of interest from the Denmark company to the Luxembourg one. The problem here was that, in the opinion of the tax authority, the beneficial owner was the private equity funds located in a non-EU country instead of the Luxembourg holding. With this situation, the ECJ decision was the following. The concept of beneficial owner of the interest within the meaning of the Interest and Royalties Directive must be interpreted as designating an entity which actually benefits from the interest that is paid to it. So, according to the directive, for being able of not applying a withholding tax in Denmark, Luxembourg should be the beneficial owner of the interest. The directive, the Interest and Royalties Directive, is based on Article 11 of the OECD Model Tax Convention in the 1996 version and has the same objective: avoiding international double taxation. The ECJ has underlined that the OECD Model Tax Convention and obviously its commentaries are relevant for the interpretation of the concept of beneficial owner under this directive. So, something new for the ECJ case law, in this case, the European Court of Justice has used the OECD Model Tax Convention for the interpretation and application of a European regulation, in this case, a directive. Under the opinion of the ECJ, in the light of the general principle of EU law that abusive practice, so having a beneficial owner in a non-EU country, is prohibited. And the Court of Justice underlined that the absence of any domestic regulation or any domestic law provision does not affect the national authorities' obligation, the national court's obligation to refuse to grant this right provided by the Directive 2003/49. So, under the ECJ opinion, although in Denmark there was no regulation about the inapplication of these tax benefits under this directive if the beneficial owner is not in the European Union, The ECJ understood that although we do not have this domestic legislation, national courts can directly apply the European Directive. So, in conclusion, prohibit the application of this directive if the beneficial owner is not inside or within the European Union. So concluding, in this case, NIN, usually known as Danish cases, the ECJ has understand the following statement. Article 1 of this Interest and Royalties Directive must be interpreted as meaning that the exemption of interest payment from any withholding tax is provided for by it is restricted solely to the beneficial owner of such interest. So for the application of this directive, it's necessary that the beneficial owner being a company inside or within the European Union, incorporated or registered under the European Union law. And also, if there is an abusive scheme, like the one we have in this situation, the national authorities, national courts, should refuse a taxpayer the application of this tax regime, the exemption of interest payment from any withholding tax, if, although in the situation in which there are no domestic legislation containing this conclusion. Thank you very much for your attention and see you in the next video. Thank you.